Welcome to a new episode of the AI with Alaa podcast. My guest today is a very special guest, Bassel El Turk. Welcome to the podcast.
Thank you, Alaa. Thank you for inviting me.
I've been looking forward to this conversation since we first had it at a friend's dinner. And we said, people should hear the questions I'm asking you and the answers and the rich answers you're giving me. Because today, everybody is asking in the age of AI, who owns what? AI is blurring the lines of ownership. And you are the man to answer these questions for me and my audience, or to help us ask smarter questions. So first of all, Bassel is an intellectual property expert and a lawyer, and I would like him to introduce himself to our audience.
Thank you, Alaa. Thank you very much. I hope I'll have time to drink the coffee today, because at the time at the dinner we couldn't eat because we were talking so much about AI and IP. I'm an intellectual property expert, a qualified lawyer. I'm the managing partner for Rouse, which is an IP business, managing partner for Middle East and Africa. So what we do at Rouse is we manage the intellectual property assets and advise on them for our clients, whether that being through legal processes and practices like litigation and enforcement, but also through prosecution and patent drafting. But we also do a lot of IP strategy advice at a government level and at private practice as well. So it's a full end-to-end IP business. What I do in terms of IP, I helped with IP legislation drafting as well in the region. So I always try to take it more to the legal side because of my legal background. I'm a fourth generation of lawyers in my family. But I'm also now, because of AI and the development of technologies, we're widening the scope of what we define as IP beyond law. And the questions around AI are very, very exciting. I'm here to ask more questions than to answer them, because this is the nature of the industry.
Yeah, and I mean, speaking of questions, I bet that all your existing clients or your new clients started flooding you with questions that weren't relevant 4 years ago, but now are very, very relevant. What are some of these questions you hear the most from your clients?
Yeah, definitely. Lot of questions from creation, so generated works made by AI. This is a very, very big question, and this is where most of the questions come from. Do these rights have certain type of IP protection? Are they recognized as IP protected works or not? And to answer that question, we can go into hundreds of podcasts and arguments, definitely. And there isn't one single answer that fits all. But this is where most people are asking questions. So AI generated works, whether that being copyrighted work or patented work or innovative, inventive work, how do we protect this? Who owns it? Who benefits from it? This is one of the areas. Other areas is in relation to liability. AI generated work that infringes upon other works. The outcome, we're talking about the outcome infringing upon other works. Who's liable for that? Third questions would be the liability in the use of the data training the AI.
Yes.
So if you're using data training the AI without the permission or the proper licenses, first of all, do you need licenses for training purposes or not? And if yes, what types of licenses? And if you don't do it, who's responsible for using it? So all of these questions around AI and how change the way we look at intellectual property throughout the whole AI ecosystem are just
And to be clear, it's not only that these questions are being asked here in the UAE. These are questions discussed by lawyers and IP experts in rooms all around the world. And different countries and different jurisdictions are coming up with different answers, or still debating them before coming up with answers, right?
Yeah, I mean, there is a lot of similarities in some of the answers because you have a lot of countries that follow big systems. Like
Yes.
they would say, "Oh, we're going to follow the American mentality."
Yeah.
Or we're going to follow the European or the UK. And these are the main jurisdictions where people are testing. Definitely, there's a lot of testing of these systems in terms of how they can deal with these difficult questions. And we're going to get to some of these examples. And some countries would actually follow, and this is where you can find the similarities. Now, the differences is because the initial definition and the way they look at intellectual property in different jurisdictions is different, right? So the definition of inventorship in the US might be slightly different than that of the UK. In the US, it says literally it has to be a human.
Okay.
So the answer would be, for a question, can an AI be listed as an inventor?
By definition, that's
By definition, it says no.
Yeah.
It's a legislative question. It's not a court question. It's not what the judge is saying. It's what the law says in this specific scenario. But in others, possibly like in Saudi Arabia, nothing says in Saudi Arabia that the inventor has to be human, and therefore it could become a court question to answer and not a legislative question to answer.
It's very interesting.
So these differences from the foundation of the law
Yes.
and the conceptual elements of why the law has been put
Yes.
would have a different outcome
In the
to answer these questions. Yeah.
So I have many questions to you about real scenarios regarding copyright, regarding IP. But first, for those like me in our audience who are uneducated on the matters of law, can you give us a brief explanation of the difference between IP, copyright, and trademark?
Okay, sure. First of all, it's all IP. So copyrights, trademarks, patents are all intellectual property rights.
One umbrella. The big umbrella is
The big umbrella is intellectual property rights. Now that umbrella is getting bigger and bigger with time. But let's first try to understand why intellectual property laws first came into. Why did we need intellectual property laws? So what the world wanted to do is to incentivize human creativity and innovation. And to do so is to help creators capture the intangible value of their creations.
Awesome.
So if you have a painter, for example, he paints a nice painting. There's a lot of creativity that goes into that painting. Now you look at it as a tangible asset, which is the actual painting. This is one thing, but that does not really capture all the intangible creation, the intangible asset in the painting itself, which is the creativity that has been put in there. How do you want to capture this? How do you want to define it? How do you want to protect it? How do you want to monetize it? So this is where intellectual property law came.
Amazing.
And it, in a way, incentivized that creation by giving monopoly rights over the intangible value of this painting, and this monopoly right would incentivize this painter and other painters. So monopoly was not to create a monopoly over the wealth, was to incentivize the creation of further intangible wealth into the economy.
Amazing.
So this is why IP law came into play. Now, what's under the umbrella of IP law? The one that mostly known to people is patent, which is mainly for inventions, to protect inventions, to give rights on inventions. You've got copyright, which is for artistic work, but also for software work. So any generated work within the software industry, within the artistic industry, applied art, abstract art, all of that, all content created is copyrighted, is protected by copyright with definitely certain legal conditions. And there's trademarks. So trademarks is any sign that you use in the course of trade to identify certain goods and services, the source of certain goods and services from other sources of goods and services. So I have BMW, it identifies and differentiates my car from the Volvo car, right? So this is how a trademark is.
So
It
let me
captures
see
the
if
value.
I got this straight. So patent is for inventions,
Yeah.
and copyright is for content, art or otherwise, and trademark is for branding and brands.
Yeah.
Awesome.
In the end course of trade, to be able to differentiate a source from another source. But
Awesome.
so anything that identifies, like three-dimensional trademark, three-dimensional shape of the Coca-Cola bottle, that's a trademark.
That's trademark.
Regardless if you have the word Coca-Cola written on it or not, because the consumer is able to identify the product as being a Coca-Cola drink from the shape of the bottle itself, regardless of the word mark on it. That makes it a trademark.
That makes it a trademark.
There's sound marks.
Okay.
Sometimes you're able to identify a certain product or a certain service from other services.
Yes.
Like
Yeah. As a trademark jingle.
sound mark
Sound
that
mark.
differentiates telecommunications service provider from others.
Yes. And for anyone else, let's take a real example from my real life. My friend Abbas is very creative. I mean, he's an engineer and he's a trader, but also he creates songs with the help of AI. So I'm going to ask you to listen for the song, and then we're gonna talk about it, ask questions.
I lay one stone, then another, and split open, learning slow. I'll make a road out of the wreckage. I make a home from what I know. Brick by brick I raise the mortar. Nail by nail I shape the light.
Okay. So first of all, let me tell you how he created it. He
First of all, we hope you took the rights to
ask you about that later.
to broadcast it
Yes.
on the podcast.
So this is going to be my next question. But let's start from the beginning. So he wrote the lyrics as a poem first. He had the ideas for this poem and he wrote them himself. Then he worked with AI, with ChatGPT, over many iterations to trim this poem and to convert it into more of a singable, song version, like lyrics for a song rather than a poem. And then he prompted Suno.ai to create the music based on these lyrics. Okay, so this is the story. Now, who owns what?
Okay, so let's go to the fundamental principles first.
Yeah.
Song.
Yes.
Who owns rights over a song?
Obviously.
There's a very big misconception that singers own the rights over a song.
It's studios.
First of all, before it goes to the studio, when the song, before it's produced, who owns the rights? It's usually co-owned between the composer
Okay.
and the poet.
The composer and the poet, yeah.
So these are the first fundamental owners of a song. The singer himself is a performer. He owns the performance rights over the song.
Those are separate.
So what we listen to now here is a mixture of several things. So let's break it down.
Yeah.
There's the lyrics,
Yes.
the original lyrics. There's the ChatGPT intervention into the lyrics to change the poem. So we're talking about the rights in the poem. And there's the music that Suno has been prompted to create by the poet himself,
By Abbas, yeah.
by Abbas. And there's a performer, who's I think is also an AI.
An AI, absolutely.
So the performance rights here is pretty much attached to Suno in a way.
Okay.
Now, the question is, does Suno have rights as an AI tool or not? That's a very difficult question. Up until today, we believe that AI tools do not have rights. They're not humans to have rights. So if we go back to when you asked me, what is IP and why was IP created? We said IP was created to incentivize human creativity.
Yes.
So it could be that us asking the questions whether an AI created or generated work should be protected by IP or not, we go back to the fundamental principles. It's not human created work, right? So the IP law was not created for the AI to create. IP law was created for humans to create. So it could be that we need a new set of laws for AI created work. Now, to answer this question here,
Yes.
in terms of what happened with ChatGPT on the poem side, it is initially Abbas's poem.
Yes.
And he, let's say, instead of using ChatGPT a few years ago, he used a dactylo to type it.
Yeah.
So he used a tool to make it readable for you because his handwriting was horrible. So you couldn't read his poem. The only way that people can read his poem is by him using a dactylo 50 years ago. Would you consider, because of that intervention of the creator of the dactylo, does the dactylo have rights to the song?
No.
They don't.
It's just a tool.
So this is just to put us in a mindset that AI, and up until today, is used as a tool to prosper human creativity. And why did Abbas go to ChatGPT? Because he wanted ChatGPT to aid his human creativity. So if there has been a sufficient human involvement in the generation of that final version of the poem, which I assume there was, but the way that you described it, then Abbas owns these rights.
Okay.
Now, what ChatGPT or Suno will try to say, they would say, we're licensing you these rights. Now, did they own the rights initially to license you the
That's my
rights?
question.
My opinion?
Yeah.
No, they don't.
Okay.
In this example, they do. Now, in terms of the music that has been created, the question is, does Abbas have rights to the music? The question is not, does Suno have rights to the music?
Yeah, and when you say Suno, we mean Suno the company, not Suno the AI. Suno the
company.
Suno
the AI. I'm talking about the AI
But
tools.
you said that Suno the AI is it doesn't have rights.
Does not
now.
have rights.
But let's talk about Suno the company versus Abbas. Okay, first the example of the dactylo is, I mean, it's far. We're not talking about the example where Abbas is typing the poem on a word editor. We're talking about Abbas typing the poem and then asking ChatGPT to trim it and fix it and convert it into a singable version. So it's not exactly equal to typing it on a dactylo.
Yeah, it's not.
Yeah. So does that mean that ChatGPT, the company behind ChatGPT, owns some creative input into his poem?
Yeah. So what I'm trying to say here is that it's the adaptation. It's not the same adaptation, but it is an adaptation.
Yes.
So if I write, and I gave that dactylo example because my handwriting is hard.
Yes.
I can't even read my own handwriting. Without dactylo or computer, I cannot read my own creation.
Okay.
So it's the adaptation of what I've done to make it readable for someone else. Like
Yes.
adaptation of my poem to make it singable.
Okay.
Right? So this intervention, you have to assess, have there been a sufficient human involvement in the end result? I believe in this scenario, there has been a sufficient human involvement.
Yes.
And AI has been used as a tool. It's like correcting my grammar.
Yeah.
I mean, this has been around for a very long period of time.
Yeah.
We used to write essays on Word. If my English is bad,
Yeah.
still the tool would correct my grammar and fix my English.
Yes, but here the difference is it's a logistic versus creative. When you say dactylo makes my text readable or Grammarly fixes my English language typos, this is more logistical intervention of the technology. In this case, we're talking about creative intervention of the technology. The ChatGPT injecting words and soon injecting music.
And this is why we talk about sufficient human involvement. And the dactylo question, we didn't ask even the question. We know it's 100% human involvement. The dactylo could not in any way generate the typed poem without my involvement. The only way that it generates each and every letter is because my involvement in each and every letter, right? So we don't even ask that question because the answer is always going to be 100% human involvement. But we took that analogy and we looked at generative AI, which AI, unlike the grammar correcting is more logistic than it's generative because it follows a certain set of rules and tells you what's right. A generative AI has more of creativity angle to it, right? Because it's generating something new that possibly did not exist and wouldn't have existed without the intervention of the AI itself.
Correct. Yes.
So the intervention of the AI is something that we understand is happening.
Okay.
Has there been a sufficient human involvement in that intervention, with that intervention? Then yes. If yes, it means that the outcome is protectable
Okay.
by IBA. So the outcome is a material, a work that can be copyrighted. And therefore, we ask who owns it.
Yes. Who owns this song?
Because we need to agree that something that we protect in copyright should be something that has human creativity, because this is why the law was created, right? So as soon as we answer that question, there has been human creativity. This is where we then ask the second question. Okay, so this is something that we can own and protect. It's protected by copyright. Who owns that copyright? It should be, in this scenario, Abbas, because Abbas had that sufficient involvement.
Yes.
And platforms like Suno, and I don't know, I haven't looked at the terms and conditions of Suno, just giving it as an example. Platforms would put terms and conditions and would say that we own and we're transferring it to you. Now, the end result is the same, but the legal concept is completely different.
Yes.
If you're assigning these rights to me, it means that you own them in the first place. So they're creating some kind of an understanding that AI tools or companies who have developed AI tools have the rights. And then this becomes a different question if we're talking about patents, which we're going to talk about later on.
Okay.
On whether an AI tool has created an invention.
Yes. So I will ask you about what Suno claims they own and they're transferring. But first, the important key point you said is sufficient human intervention. We know for sure that there has been a sufficient human intervention on the lyrics side. Predominantly, it was done by Abbas with some help from AI. When we go to the second part of the creation, which is Suno, predominantly the work was done with Suno with guidance and prompting from Abbas.
Yeah.
So does this create a problem? So some people can argue there is sufficient involvement on the lyrics side and less involvement on the music side. Who owns the final product, the song?
Yeah. So we have three questions. Whether AI can completely generate something on its own.
Yes.
Without any prompting. This is a futuristic question or robotics or whatever. We're not going to ask this question today. But if we're asking this question today, the answer, because of the legal system, there are no rights. These works have no rights. They don't create any rights. There's a human involvement that generated something with the AI, which is the case that we now have in terms of the music and in terms of the lyrics. And now that's a big spectrum.
Yes.
We look at the lyrics side, it's on one side of the spectrum, but on the music side, there's another side of the spectrum.
Yeah.
Is Abbas a composer? Is he a musician?
No. It's a hobby.
It's a hobby?
Yeah.
Did he do any music before Suno's existence?
Not professionally, no.
Not professionally. We then have to get an expert in the field of music to see what is Abbas' intervention in the creation of that music and whether that creates. It's not one answer.
So we can't answer this question today. You're telling me we can't answer if Abbas owns this song.
No, I mean I did something on an AI platform once, a poem in Arabic and the melody. So when I was younger, I had that song that I created melody. I don't know how to compose music, but I wrote the poem and I sang the poem in a certain melody and a certain style. So what I did with that platform is that I recorded my voice singing it. So what the platform has done has created a cover for the song
Yeah.
by using my style, using my melody, but reproducing it in different ways.
Yes.
Okay. With my lyrics. Now the question is, did I have sufficient intervention? I believe because I had the melody and the lyrics, possibly I do have sufficient human intervention in the creation of that final product.
Yes. Let me share with you what Suno said, and he sent me a screenshot about this. He said, it said in his pro subscription, you get Suno's best model, 2,500 credits, and the rights for commercial use. Yeah. That's what it said on the rights for commercial use. He sent me the full terms of service. I'm not going to read all of them, but let's go back to the question. Does Suno, the company, own the rights for commercial use to begin with? We know that Suno, the AI, doesn't, so that they assign them to Abbas. And can Abbas today go and use this song he created everywhere in the UAE, everywhere in the world, while being 100% on the right side of the law?
Yeah. I mean, this is a contractual question more than it's a pure legal one as well. So if at the end of the study and everything, we realize that Abbas owns the rights to commercial use, right? And he approved terms and conditions that says Suno has the rights to the commercial use at the end of that relationship that produced that end product. The question becomes, okay, we say, Abbas, you had the rights, but you assigned them contractually by accepting the terms or conditions of Suno. So you can see that the way that lawyers have drafted terms and conditions, they still use vague terms. They didn't use assigned because they don't know who owns, but they say who has the end result. So if the court finds out, okay, Bassel owns these rights, but Bassel has signed these terms and conditions and agreed that Suno will have these rights, it means, could be, one of the answers could be, Bassel has agreed that if he had the rights, he would assign them to Suno. So it becomes more of a contractual question than an actual legal question from who owns it from the outset.
And the fact that I played the song now on this podcast, again, it would be legal or illegal. I mean, Abbas could sue me or not sue me based after we do the research and we determine if Abbas owns the song or not.
Yeah, I mean, I don't want to give Abbas free legal advice on the podcast, but it's a very valid question, but it's very clear that you're using it for educational purposes in a way, for awareness, and you know Abbas, so I assume he already knows about this, but she didn't really broadcast the full song for commercial purposes. Now, obviously, if he wants to take action or claim some rights, he would have some aspects of rights that he can try to claim. However, in the context of this podcast, it's not really, you're not really using it for commercial purposes as a song.
Right. Let's talk about a different question about the same song, which goes into the question of plagiarism rather than just ownership, right? So the first time I heard the song, it reminded me of a Linkin Park style.
Yeah.
Okay. He said it's very similar to U2 / Linkin Park, a blend between both. Now, he did not prompt Suno to say, use the style of Linkin Park. I'll ask you this question later. He just prompted Suno to create what it had created. But let's say now we Shazam the song and it finds some chunks that are similar to the style of Linkin Park or the style of U2. Can Linkin Park or U2 sue Abbas? Can they sue Suno?
Yeah, so it comes back to the question of liability. Who's liable for the outcome, for the generated work when it possibly infringes upon other works? And that's not a question that is only for AI generated work. I mean, there's a lot of songs out there that have been influenced by with certain styles, with certain lyrics, with certain musics.
Yes.
You've got a lot of Arabic songs. I mean,
Yes.
you listen to Arabic songs that have copied a lot of sections and fragments of music
Sampling.
from sampling,
Sampling.
from other songs as well.
Yeah.
And there has been a lot of cases around that, saying you've used that melody from my song, and there's been a lot of cases. It happens a lot.
Yeah.
It happens even unintentionally with human creativity.
Yes.
So you would not, maybe you don't know that you're using something, but it's back there, and subconsciously it's there in your head.
And is the threshold here again sufficient or insufficient? So I know some sampling is okay, and then a lot of sampling is not okay. Famously, for example, Sting sued P. Diddy for every step you take, every step I take, because they said that it was not just sampling; it was too much sampling, and now he pays him a lot of money.
Yeah.
So
So it's again depending on how substantive the copying is.
yes.
And the most important question here is originality. So in copyright, you don't look at whether your work is novel or not. You did a new thing. Unlike patents. Patents, it's all about novelty, inventive step, innovation. Copyright is about originality. So let's say Abbas' song, his lyrics. He wrote these down in 2003.
Yeah.
Right? Let's say I've written a poem in 2006. Never heard Abbas' song. That actually not copied, but had the same originally, the same 5 or 6 sentences. Coincidentally. My work is original and his work is original. So when it comes to that question of originality, we both have rights.
Okay.
Because the question in copyright is originality and not novelty. So in these scenarios where the music copies a certain style because it's influenced by this style, but it's still original enough.
Okay.
And originality here would actually depend on how substantive and substantial the copying was, if we can call it copying. Then we would be deciding whether royalties would have to be paid or not.
So I think this is a question that people ask, not only for songs, but also for when I ask ChatGPT, like GPT Image 2 or Nano Banana, create or reimagine the Mona Lisa in the style of Vincent van Gogh, or create a picture of a poodle skiing on the Alps in the style of Pablo Picasso. Am I breaking any laws?
In these specific examples, no. The reason is they're out of copyright, because copyright, depending on the jurisdiction, is usually 50 years to 70 years after the death of the artist.
Okay.
So, but what you need to be very careful with is the moral rights to the work.
Okay.
So the artists have 2 sets of rights in copyright. Has a moral right that does not expire,
Okay.
which is the right to be named as the artist, credited as the artist of that work, and not being defamed, not to use his work in a defamatory way. So these rights do not expire. If then after his death, it goes to his
Estate.
estate. Yeah. And there's the financial rights. The financial rights are the rights that expire. So you shouldn't be paying royalties to use the Mona Lisa. However, you should use it in a way where you don't defame the artist, and you don't discredit the artist from that work. Now, the Mona Lisa is very, very famous. It's going to be very difficult for you, someone to argue that, you're saying that you did the Mona Lisa. I don't think that argument would hold in court. So even if you didn't say that Leonardo da Vinci painted the Mona Lisa, you're still not. I don't think you're infringing a law.
But if you say in the style of, I mean, can people copyright their style, not just the product? Can people say Picasso's way of painting is also copyrightable, and nobody should, create their own art in the style of Picasso?
Yeah.
Is this a thing?
It is a thing in many cases. And again, we go to the question of substantial copying.
Yes.
Now, it's not a thing under the law. There's no section in the law that says you can't copy, especially in the UAE law, you can't copy a style of someone.
Okay.
But it is in terms of if the artist makes a living out of his art,
Yes.
it's a competition question. It's a fair and unfair competition question. Are you trying to free ride on that artist's reputation for commercial purposes? So that becomes, then you go down to the fundamental legal principles in terms of what's a fair competition and what's an unfair competition. Because even in artistic work, artists do make a living out of, it's a commercial question.
Yeah.
Because some artists get very sensitive saying, no, it's not a commercial question. It's always an artistic question. But if you want to take it legally, it becomes a commercial question, and it's commercial competition. So you go back to see, have this artist who's commercializing his work being doing this fairly, or is he copying someone else's style to benefit unfairly from his competitor's reputation? And that's in trade, that's in art, that's in any commercial.
How can you answer this question? You have to go to the intent. I mean, you have to be in their head to know.
I mean, there are some, you can find some evidence of the styles they've been using, the way he's selling. I mean, it goes back to going into a shop in Dubai Mall that copies 100%, let's say, another shop, the way, the style of selling and whatever, and the concept and the architecture and the layout, and trying to pose themselves as different, as someone else, right? Then that's a commercial competition question. Now, it is difficult. It's a proving question. It's not a legal question. So legally, you should not be unfairly competing with someone else. Now, how to prove that in court, that's a practical question. You need to have a good lawyer who is able to gather as much evidence. It depends on the system. If you're in the US, there's that discovery in the US. Over here, there's no discovery.
Yes.
So out of discovery, possibly you can get some information on why they did that, how did they do it, and therefore build a better case. This
Goes about the question of sufficient, non-sufficient, originality versus novelty. Let's. You also mentioned an important point, which is 70 years after the death of the original artist. So the answer becomes different if the artist is alive or dead. Let's take two examples. One example is Vincent van Gogh, and one example, my friend who is a local Lebanese artist, Christelle Bshara. Okay, let's say I go to ChatGPT and I say, create a picture of a poodle skiing on the Alps in the style of Vincent van Gogh, and then I say in the style of Christelle Bshara, and both of them have their signature style, right? And then I take this result and I print it on a mug and I sell the mug, and I make money out of these creations, AI creations in the style of someone else. Clearly, there is no sufficient involvement from me. I just told ChatGPT, created in the style of Van Gogh, in the style of Christelle. Am I breaking the law selling these mugs?
So first of all, sufficient involvement from you is a question of whether you have rights to it or not. That's not the question whether you're liable or not.
Okay.
So liability here comes from your intent to copy a style.
Yes.
Whether you're sufficiently involved or not,
Okay.
if the outcome work, generated work, is considered to be infringing work, then we ask a question of liability. We're asking a question of ownership.
Right.
Whether you own it or you don't own it,
Separate question.
separate question. It's like
IP versus liability, infringement. Yeah.
So actually, the answer would be you don't own it because it's infringing. So because the only reason it's infringing because it's infringing upon rights of third parties who own aspects of that right, of the style and whatever. So again, the answer to whether selling these mugs is legal or illegal is first, is the outcome of the generated work infringing enough in terms of copyright question?
Well, what's your opinion on that? Is it infringing or is it not?
We have to see the style. So the question becomes factual. So whether you say copy the style of X artist.
Yes.
ChatGPT.
I don't want to use the word copy. Let's make it very
put it in style.
in the style of Vincent, in the style of Christian.
The outcome would be different every time you ask the question. Every time you prompt it, you're going to have a different outcome.
Correct.
Maybe some of the outcomes will be, it has a hallucination of not the style.
Someone
else's style, right? So this is why it becomes a factual question. You have to see the question inside. The prompt itself is not infringing. The prompt is not the infringement. The generated work is the infringement. So you need to look at the generated work and see whether ChatGPT have actually reached the stage in the generated work that creates an infringement.
Okay.
So, and you need to look at each and every outcome. And especially
how do you measure this? I mean, people know when they look at a painting that this is Van Gogh style. They don't just count the number of brushes that are in, and they say if there are more than 70% that it's a Van Gogh style. So how do lawyers decide whether it's sufficiently copying Van Gogh style or not?
So the lawyers will not decide, the courts will. The lawyers will guide the parties and the court into making a decision. And again, here we have the copyright question and we have the competition question. Because you're putting it on mugs, you're commercializing it in a manner where you're generating revenue. You're getting revenue out of it. So it becomes more of a competition question here, more than a copyright question. Even if we say that generally from a copyright question, possibly it's not a sufficient infringement of copyright because it's only the style, you're not copying any elements, then it's not a copyright infringement. But if you go back to the principles of fair competition, then possibly a lawyer can bring that argument, saying what you're doing, you're competing unfairly with the owner of that style. Now, the style itself does not give you rights. But what you're saying, the commercial activity of the artist and your commercial activity are competing. You're using elements of his commercial activity to pose yourself as a similar or an alternative competitor benefiting from his reputation.
I'm not claiming to be an artist competing with, Van Gogh or Cristal. I'm just, making money out of a style similar to their style without compensating them.
Possibly they don't want you to compensate.
Yeah, because they don't want it. Can they? Can she sue me?
Yeah. First, there's two things here. First, possibly they don't want you to compensate them because they don't want to get into that line of business, right? And second, they might think that you're damaging their reputation because people do think, seeing your style. I mean, and that's a matter of evidence. I mean, I can do surveys showing people the painting style and say, and we've done this in courts before as part of how we prove something in court. So we do surveys. We just show them a picture on a mug, right? Say, who drew this? Oh, Bassel El Turk.
Okay.
Who drew it? And then we will get, let's say, 80% of the people thought that it's Bassel El Turk.
Okay.
So there is a sufficient copying here, and possibly, if it's not a copyright question, competition question, you're benefiting financially from Bassel El Turk, and you shouldn't.
And you also mentioned the reputational damage. She might want her paintings and her style to be only expressed in paintings that are displayed prominently in saloons rather than on merchandise like a mug,
Exactly.
right?
Yeah.
So
They don't want to be commercialized. So it's not always paying them for what you're doing in their name, because possibly they don't want their name on this, right? But there's a very, I think maybe when you were in Lebanon, you've gone through this. There was a singer, George Wassouf.
yes, of course.
So George Wassouf has a very particular
Style.
style.
Yeah.
There was a singer back in the late 90s who sang a song on a Lebanese channel, radio, and they didn't mention the name. And it was very similar to George Wassouf's voice. And people actually thought it was George Wassouf.
Wow.
I'm one of the people who thought it was George Wassouf. So I went to store, I wanted to buy the new album of George Wassouf, and they were like, no, he didn't do a new album. I was like, what about this song? Oh, this is a single on this channel
By someone else.
who we don't know who he is.
Wow.
And until later on, he also became famous and we knew who that guy is. But if you think about it, he benefited from not putting his name on it for some time. Because people started listening to it more and more and more, thinking that it was
Created a hype, and then he announced and said.
and announced. Now, does Wassouf have right on his style and voice?
The
all like that?
lightness of his
The
voice.
lightness of his voice?
Yeah.
It would have been extremely difficult to prove from a copyright IP perspective.
Yes.
Now, if you want to go down the route of a commercial competition perspective, did this guy do sufficiently negative actions? So instead of positive actions, so sometimes in commerce, not every, if I want to prove that you've unfairly competed with me, I don't have to prove it by showing something that you've done. I can prove it by showing that something that you haven't done, you should have done, like not putting your name on it.
Give
right?
any credit or.
You should have said that it's Bassel El Turk singing. You didn't say, and people assumed it was Wassouf. So your negative attitude by not doing what you should have done created the confusion, and that confusion created an unfair competition in a way.
Yeah.
Right? So
But you can't copyright your voice.
No. And this is why it's not a copyright question.
Yeah.
So it's not an IP question. It's a commercial
Commercial competition
Competition
infringement question. 100. Awesome. I mean, I have so many other questions to ask you, and we're going to take a short break. During the break, you were explaining to me the 3 buckets that we could tackle these questions from. And you said there's the AI as a software. Who owns it and the rights to it, and then the applications on AI, and then when you put AI on a hardware, and we go into the patent part. So I thought this was super interesting, and I want you to do it and re-explain it to the audience.
Yeah, thank you very much. So when we started that conversation, we said that many questions come out in relation to the IP rights in the generated work, the outcome of AI. Right? But the fundamental questions that we should ask first, which a lot of companies are asking, especially in the technology space, is the IP rights in the AI itself. So while you're creating an AI software for certain reasons,
Yes.
who owns the rights in the AI and what types of rights are there? Definitely, because AI is a software and softwares are mainly and fundamentally protected by copyright, then initially AI is protected by copyright.
Yes.
AI as a software.
Yeah, the 200 lines of code that constitute the neural network that was trained.
Exactly. And it's the same questions in relation to any other software. Are you infringing on other softwares? You're not infringing on other softwares. This whole thing is copyrighted. Now, when does this move more into the patent space is when you put that software in a certain application that impacts hardware, right? So you put that software in a pen that when you write, it analyzes what you're writing, for example.
On a computer in a car that drives itself.
Exactly. So every time the AI is applied to another hardware and impacting the outcome of how this hardware behaves, this application becomes a pattern. And this is where most of patents relating to AI are being filed. Now, some patents are being filed for software only. It is very difficult to be granted a patent when it doesn't have that application. That's everywhere in the world, especially in the US. However, when you apply it to a hardware, this is where you can get a patent. Definitely, there's all the other questions, obviousness, is there an inventive step? Are you solving a technical problem? All these questions that relate to any other patent, whether it's AI related or not, have to be asked to be granted.
So you can't patent software. It has to be a software installed on a hardware to be eligible for patent.
Yeah. So most systems would treat softwares as code, as language, as content, and therefore it's copyrighted. It's not patented. When that software has an impact on a hardware in an inventive way, then this is where you can be granted the patent rather than a copyright protection.
Let's take an example of a software that can translate from any language to any language. Yeah, I can ask ChatGPT to translate from any language to any language. So you're saying, as long as this translation is only in software form, it's sitting on the cloud, and I'm getting it through my phone. It's not sitting on my phone. I'm getting it through my phone. Then there is no eligibility for patent. But if then I embed it inside an earphones so that when you talk to me in English, I hear it in Arabic and vice versa. So now it's a patented product?
It could become.
Okay.
So it gets more eligibility for it to become patented. So it's answering whether a product is eligible. A work is eligible for being granted as a patent or not is a very complex question, right? Because it also depends on the industry, depends on the prior art. Has there been any prior art who dealt with this question in the same way? It depends on how you draft your claims. So there's
But why the hardware bias? Why is it, the general leaning in the law? As I'm understanding, you're saying if it's on a hardware, then it's patentable or eligible to be patentable, and if it's not on a hardware, then probably not eligible.
Yeah,
but why this hardware bias?
So when we're saying not eligible, we're not saying there's no protection, right? We're saying it's protected under copyright, by copyright. Yeah. So let's just make sure that there is some kind of protection here, because we're incentivizing human creativity by any school of IP law. So that hardware element question has been in arguments and in courts for a very long period of time. Previously in the US, you didn't need to show that hardware impact. So the software itself could actually entertain patent protection. And that was, in a way, a political decision in the United States. And because they wanted to encourage more software creation, right? And that was during the rise of the internet. And throughout the 90s, they wanted people to invest more into that space.
Yes.
So they made a decision that you'll be granted a patent. Why patent and not copyright? Because it's much easier for you to prove ownership on a patent and to enforce a patent and to claim the compensations and royalties when you have a patent.
Okay.
Right? So, but the patent protection is much shorter than copyright protection. So the patent protection is 20 years from the creation, non-renewable.
Okay.
Copyright protection, we said in the US, it's 70 years after the death of the creator, right? So it's a much longer benefit that you get, but it's much harder enforcement
to prove that
that the practicality is this problem becomes a problem. Now, why they've added that hardware angle to it? Because they wanted to apply this creativity to our day-to-day lives, to show that it's making an impact. It's making that change.
Yeah.
It's not just a software that's sitting over there. We needed to prove that it's making this change to our world, to push creativity even further and innovation even further.
I think laws should keep up. I mean, our life is increasingly more software than hardware. And I think this bias to software is not as real as hardware will go away with time. But that's a separate topic. I'm also interested in those who aren't being compensated. Let's say they train Midjourney, the AI, or they train GPT-2, OpenAI trains GPT-2 on 1 billion images on the internet and out there in the world. And now Midjourney and GPT Image 2 can create beautiful images. Now, they're creating these images not necessarily in the same style of the artists who created the billion images on the internet, but only because of that training data, this AI is able to be any sort of useful today. Is there an argument for these original artists, needing to be compensated by OpenAI or Midjourney?
So that question goes back to the training data. What rights are there in the training data to begin with? And this opens the question on, are we going to continue just giving free data to AI to train them?
Yeah.
There's a lot of systems that are encouraging this. There's a court decision in Japan that says training, even protected material within the training data, you don't require royalties to train a machine. You can use it. So laws will have to deal with this going forward. I mean, there's going to be some kind of change on the perspective to see whether this data should be protected or not. I mean, if you think about it, when something new is introduced, humans and legislators, they argue that because it's new, they argue that current laws or current conceptions or principles don't apply. It happened the same thing during the digital music world, for example. When digital music came up, people started asking questions. If I download a song, do I need to pay royalties? Or is copyright only for a recording, for an actual terminology of recording? It needs to be on a disc or on a cassette or something like that. This software,
MP4,
this software doesn't have what it needs for the music to be copyrighted music, because the way we look at the content that creates this was different. What we missed out on is that it's not the content what defines it in such way. It's a representation of the outcome. So digital, it's only a representation of the actual content.
Right?
So it should be protected. Actually, it should be more protected now, because you're creating a bigger problem. You're creating a bigger problem. You can't copy it easily. So it becomes a tool that raises a lot of questions. It's the same thing now is happening with training data. Some argue, of course you have to pay rights. And they come from a pure right holder perspective. Some argue, no, you shouldn't, because if you do that, you're limiting the training capability of AI. We need the AI to get better. We shouldn't be limiting that. And some argue, from a competitive perspective, if you look at the AI as a competitor of a human being, that they need to pay as much royalties as we do. When we go to school, when I'm training my kids, when I buy them a book, I'm paying for that book, right? So when I'm training their mind by reading new stories and new books and new encyclopedias, I'm paying for that. Why would a human who's my kid have to be financially impacted to train himself, but AI doesn't. When at the end of the game, AI might be competing with my child at as
So if
workforce,
the
right?
trainers, if the labs who are training these AIs pay for these books, then they're in the right. So let's say Anthropic, and that's a famous case. Let's say they paid for 1 million books, and they bought them. But instead of having a human child read them, they had the machine read them. Are they not in the wrong because they paid for the books and they paid the royalty, or are they in the wrong because they should pay more because now it's a machine that can gobble this much faster?
Yeah. So the question is, what's the purpose of copying? I mean, when you buy these books, but you create a digital format for training purposes for an AI, is that a right use of the license for you? That becomes also
Is there a law that answers that?
I mean, what I think is happening today is that a lot of systems are turning a blind eye, and I understand why.
Yeah.
Because we need AI. People, consumers need AI. Businesses, they need AI. They're investing a lot of money in AI businesses and machines and futurely robotics or whatever. So they don't want to answer that question today.
Unless it's brought to court.
Unless it's brought to court.
You have to answer.
And then they will answer it not from a law perspective, from a factual perspective on this specific case.
Okay.
So they're not creating case law that is actually going to become new legislation.
Precedent.
It's precedent.
Okay.
Japan,
Yeah.
we believe that they're going into the direction where you don't really need to, up until now, you don't really need to pay for these. It's for free to train AI with the material. Yeah.
So I have an example about what you just mentioned, which is it's case by case. Okay. Are you following the lawsuit between the New York Times and OpenAI and Microsoft? So there was this lawsuit that New York Times brought in America, showing examples of when you ask ChatGPT to, let's say, generate an article about the protest of the taxi drivers in New York City, the resulting essay had a lot of exact same sentences, sometimes full paragraphs that are extracted from articles by the New York Times. So the question here is, could OpenAI argue, hey, we paid the monthly subscription to New York Times, but instead of giving it to our human employees, we used it to train our AI employee who's like a journalism student and now he's writing similar essay. Could they argue that? Or because of the nature of AI, who is much, much broader than the human brain, New York Times can say, no, this is unfair use of our $5 subscription per month.
Yeah, I mean, these are the arguments, right?
Yeah, these are the arguments.
So these are exactly the arguments. So whether they can or, of course, they can argue that.
Yeah.
Whether it stands in court, I'm of the view
What do you think?
So I'm of the view that the laws and practices today are not ready enough to answer that question.
Yes.
I'm of the view that in the AI world, we need to have a different set of rules. As you exactly described it now, that an AI brain is different than a human brain.
Yeah.
Right. And we can't really call it as brain, but let's just metaphorically, it's different. It functions in a completely different way, and therefore that capacity have to have an impact on how it uses the information because of the capacity. So this is why maybe $5 is not enough.
Yeah.
Because you have much bigger capacity in the way you're dealing with this information.
Yeah.
So I think we shouldn't be trying to answer all of these questions, which is the case now, using our current IP law systems.
Okay.
As we started this conversation, we said IP laws have been created to, first, encourage human creativity, encourage human innovation, to deal with localization of trade and inventions.
Yes.
So trademarks are territorial rights, patents are territorial rights. Now you're trying to apply these IP laws with these important principles to AI.
Yeah.
AI is not human creativity.
complete different
AI
beast.
generated work is not a human creativity.
Yeah.
AI generated inventions is not human innovation. AI is not a localized product at all. It doesn't take localization into consideration at all. Actually, it takes you from your seat anywhere in the world.
Anywhere on the planet.
So the fundamental principles of why we have AI
Yes.
are completely
Yes.
opposite to the fundamental principles of why we have IP laws.
Yeah.
And this is why we need, and I call for that, a new set of laws that deal with AI without changing the IP laws. AI is not changing our IP laws. AI is disrupting the fundamental principles why we created these laws. And therefore, we need to look at, do we still need IP laws? Of course we do, because we still need human creativity. We still need localization. We still need innovation. So we still need these IP laws. What AI is creating is something completely new. Possibly we need a new set of AI-related laws that would deal with these
So
questions.
your advice is keep the IP laws, expand them, but come up with new laws that deal with the definition of what AI is as this new entity.
Without disrupting the principles of why IP laws have were
Yes.
created
And-
for human creativity.
And until these laws materialize, these new laws materialize, a lot of people are playing in this lost time in the gray area. For example, ByteDance a few weeks ago released their new AI that creates video, C-Dance. And C-Dance was famously marketed online through a fight scene between Tom Cruise and Brad Pitt. And this fight scene on Instagram went all over the world. Do they have the right to do that? I mean, aren't they infringing on the likeness of Tom Cruise and Brad Pitt? Aren't they infringing on the rights of the studio, some studio in Hollywood, who owns similar scenes that were used to train C-Dance to generate this scene?
Yeah, I mean, I'm not gonna. I mean, we talked about Suno, and now we're talking about an example.
C-Dance.
ByteDance, C-Dance. I just want to make sure that
They're the same.
that these are examples in the real world, and we're not advising on these particular rights.
Yes,
It's just
yes. Examples.
These are examples that being used just to simplify the
Educational purpose.
Yes, that simplify the theoretical aspect of the overlap of AI and IP.
Yes.
And I'm not being, I mean, I didn't comment on specifically what Suno's terms and conditions of that creation is. It was just talking abstractly the same thing here with ByteDance. I haven't seen the videos. That the question would then be, have they got any rights? We don't know if they actually had the rights. They've reached out to get these rights. Who created these videos? Is it the company itself, or is it a user of the company? A lot of questions would change the outcome of the answer.
Let's take both options. Option one, the company created this video to promote their new video model. Option number two, the company just released the video model, and then a user called Alaa prompted it to do a fight scene between Tom Cruise and Brad Pitt without obtaining any rights for likeness or any right for the video production.
I mean, in the first case, every time you're going to hold someone liable, it has to be someone who made an action.
Yes.
And that action that they've done, they would be liable for it.
Yes.
Even if they used a tool or didn't use a tool. There's always a concept called contributory liability.
Yes.
So there you have a contribution to that liability. Any type of crime, any type of infringement, you might have 2 or 3 people contributing to that action, right? So here, again, you have to see, is that platform built to infringe upon other rights? Then definitely the company creating the tool would be liable for building a tool. Its purpose is to, which is not the case.
I don't think
here.
that's the case.
Which is not the
but
case
regardless
here.
of the purpose, I mean, the use, regardless of the purpose of why this was built it was built in the first place to allow people to create images, videos from text. But now somebody used it to create a fight scene between Tom Cruise and Brad Pitt.
It's like when the VHS added the function of recording.
Yes.
Before you were just able to watch a movie. Then you can record something from TV, live feed, you can record it on the tape, right? Was it created for the mere purpose to infringe upon the TV rights? No. But still, it's been used. So if you're using it for infringing purposes, it's like, I mean, the simplest example is a steak knife. You can cut a steak and you can commit a crime. So these platforms, the only things that with AI, because it's so scalable, that it highlights all of these questions. But these questions are valid questions on any type of crime. So are you using the platform to create? Now, some countries, some jurisdictions would say that even if your platform is not merely made only for infringement, you should have enough and sufficient procedures in place for people who were infringed to file a complaint and you take action by taking out that product or taking it off. Or you have to have clear disclaimers. You have to have clear awareness and education to the users on how they use. You need to have a clear softwares in place or some spywares within your system that would go and test.
Tell the user. So let's say ByteDance did all that, and then me as a user, I just prompted CDance create a fight scene between Brad Pitt and Tom Cruise. Okay, can Tom Cruise and Brad Pitt sue me, the user? Forget ByteDance. If I posted it on my Instagram and it went viral,
so you
can I make money out of this virality?
Yeah. So you creating it is one thing.
Yes.
You publishing it, putting it on.
Yes.
On your
Instagram. It and I published it, and it got the attention of Tom Cruise and Brad Pitt, and they sued me. Do they have the right to sue me?
They should have the right to sue you based on their own likeness.
Yes.
Usually these famous artists, they have not only rights to their likeness, but they actually license these rights. So their likeness is managed by agents.
Excellent.
Right? And they get paid for it.
Very good.
So that would, if you're using it especially for commercial purposes, now you would argue, no, it's not for commercial purposes, it's just a fun video, but
it got me a million views.
Yeah,
I started getting sponsors, so indirectly I made money.
Yeah. So the argument that, I'm just using it for personal purposes on social media is much more commercial today than it was 10 years ago, right? Yeah. So we can't, now there's a very fine line on what's personal and what's commercial on social media. But again, it's an element of evidence and proof and argument in court. And this is why lawyers exist.
Awesome. Yeah, but you must have a lot of work now, even 10 times more than you had before. But on the subject of likeness, so let's take someone not internationally famous, but locally famous. We are working with an actress and an influencer here in the UAE. In Cognate, we also have an AI studio, and we create AI films, but we're also creating AI digital twins. Now, with the consent of this artist, this actress, and her agent, we're creating a digital twin for her and putting her in different situations, filming different ads of different brands. And we think that this will open up a new work opportunities, regardless of the location, for anyone who's an actor or an influencer. What does the law say in this regards about using her likeness to create a digital twin? And who owns that digital twin, and who owns the resulting ad that we created with her digital twin okay, doing a car commercial.
Yeah, I mean the right to your likeness, how you look, is protected as a personal right.
If you're famous.
Not only if you're famous. Let's say I go today. I want to apply for a visa, which we always do, and I went to the photographer, and he takes photo of me. Right, he owns copyright over the photo because the photography is an art by itself, and the way he takes the photography is he owns that copyright.
Yes.
In the photo itself, but he doesn't have right to my likeness.
Yes.
So he has the right, he has the copyright in the photo, but he cannot publish that photo without my permission. Why? I have to give him a permission to put my face on something.
Yes.
Yeah. Without my permission, it's not allowed.
Clear.
So when he creates a digital twin,
In this case, Shahzad is the artist, and he used AI tools to create a digital twin
from a person. Yeah.
So what you're saying is Masa still owns her likeness, and Shahzad owns
Copyright in the digital twin, but he can't use that twin
without her permission.
without her permission.
Clear.
Right?
Clear.
So and these are two different things.
The photography example makes it very clear. Thank you.
So, and these are two separate things. And the question is, now she has a right. The question is still not answered. Can she give you that right? I mean, God forbid I hope she has a very nice long life, but can she give you that right to use it further beyond her life? Because the digital twin will continue to exist. Right?
Yes.
Now that's a complex question.
Oh,
That's
digital twin becomes something that you can inherit to your estate or
because
to
she does not exist as a person anymore, but her twin continues to exist, right? Digital.
Wow, who benefits from the app done by the digital twin?
Is she able to sell you that on her, I mean, throughout her life and beyond?
Yeah.
Is it something for her estate to decide later on? We haven't.
People are selling likeness. Kabi Lame very famously sold his likeness for something like $1 billion. Yeah. So people are starting to sell likeness as an asset.
Yeah, but for how is it selling or licensing? So the question is, does it have an expiry date?
Yes, I don't know.
And the person who bought it, can he sell it again? So let's say I buy your likeness for $100,000, then you become very, very, very famous. Can I sell it to someone else for $200,000 and make money out of it because your value on top?
Yes.
Or do you have the right to come back to me and ask for a fairer compensation? There's something called fair compensation under copyright law. And the question is, does that apply to likeness as well? If you sell or license your likeness. So if I created something within my company and I assign it to the company, a software or whatever, and then the company made billions out of it. I assigned it to them. They gave me $10,000.
Yeah.
Which I thought was fair, right?
Yeah.
And then we didn't know there was the next thing that
the next big thing.
Yeah, the next big thing, the next thing that the world was waiting for and didn't know they were waiting for. And boom, it
Should you
exploded
be
everywhere.
compensated?
Yeah. So law says yes. You should be compensated.
Awesome.
It happened with the creator of the company.
When you say the law, you mean the US law, the UAE law, the UK law?
It's a common principle
Okay.
under different sets of laws in different jurisdictions. It's an agreed common understanding of a principle that you should get a fair compensation.
It's like a human value coded into law. Right?
It happened. I mean, there's a story about the compact disc. This is what happened. The creator of the compact disc went back into the company and said, look, you only paid me peanuts because the compact disc changed the whole world. Yeah. We were just talking about digitalization of music, right? It helped get us into that stage. It was a stepping stone.
Super interesting. But now, I mean, every time you answer something, you make me come up with many more questions. So when you answered the likeness question, you tackled it from the angle of this person making money out of their likeness by being an actor or an influencer or a public personality. Okay, but we also know that the likeness has other angles, not just commercial, but safety, security. We know that people are now using AI tools to create deep fakes, and you can do a lot of harm with these deep fakes. And some countries like Denmark is trying to tackle this by issuing a likeness ownership law that applies to everyone, whether you're a public personality or not, whether you make money out of your personality and likeness or not. Do you think this is the way to go? Do you think every country should follow suit?
I mean, it's interesting what Denmark is doing. Impersonating in general is a crime.
Okay.
It has different levels of crime. If you're impersonating for commercial benefit, if you're impersonating a government official, if you're impersonating, it has different levels of crime. Now, the question is, deep fake impersonating someone, is it impersonation, or does it have to be an actual person claiming to be someone else? And this is, again, a question that different courts would be dealing.
Yet?
No, it would be answered. I mean, in my view, it is an impersonation. Sending an email and signing it is an impersonation without me having to see that person. So what if I see someone? I mean, an email is a digital format of impersonation, right? If I send an email, and there's something, by the way, now in the IP industry, funny enough, that there is an AI, possibly an AI-backed impersonation tool that's sending emails in the name of IP lawyers to brand owners around the world. IP lawyers in the UAE, so this is like signing my name and other lawyers' names, sending it to many brand owners around the world and asking them to register their trademarks in some jurisdictions, right? And it's possibly some phishing emails here, because I don't think they're going to get that work, but what they're trying to do, possibly say, oh, my mark is not registered, let me send me $500, I'll do it for you, and they'll just take the $100 and then disappear. But that's an AI impersonating by sending emails only, without actually seeing the person. So adding that level of seeing the actual deep fake is even further in terms of, so I don't have to prove that it's an impersonation.
Email scam is a crime. Deepfake
is a bigger crime and easier to prove. Because if someone signs Bassel El Turk, they might argue, yeah, he is a different Bassel El Turk. You're not the only Bassel El Turk, right?
How do you chase
but
the
if you're
person?
in my face,
But how do you chase the person who created the deepfake?
I mean, that's
That's an enforcement question.
Yeah, that's an enforcement technical question. And this is why I say, in the age of AI, the future IP lawyer is not the best lawyer.
Who's the best lawyer?
Someone who understands the technical aspects of artificial intelligence, someone who has technology education, someone who has, technical background. Not
So an AI engineer that studies law, or a lawyer that studies computer scientists?
both.
Yeah,
Both.
encouraging kids to follow a new, educational path.
I come from an IP field, so a lot of my colleagues have technical background, because you can't have a patent attorney drafting an invention on behalf of an inventor if he doesn't understand the technical aspects of the invention, right? So we have people who have PhD in chemistry and medicine and physics,
advising the IP lawyer on what?
No, they are the IP lawyers as well. So they study law.
Okay.
And they study and they do masters and PhD degrees in a technical background. And then when they sit with an inventor could be a 25-year-old programmer, right? He's not able to draft a patent application that would hold legally in a court of law. He needs someone who speaks his language, but at the same time speaks the authorities' language.
The law's language.
And the law's language. So we'll be able to draft it in that way with the claims and make sure that it holds in a court of law, it holds in enforceability, it holds in examination. It's distinctive enough and innovative enough and inventive enough in relation to prior art. So you need that person. Now, this is in the patent space. I think this has to expand to further to all IP professionals.
Yes.
Every IP professional now is going to be asked question around technology and AI. Whether you're a litigator, whether you're an enforcement specialist, whether you are a prosecution specialist, whether you are an IP advisor, strategist within IP, you're going to have to understand
The
the technical aspects, or you won't be able to
There you go. That's a career advice from our guest. Kids, if you're in AI or computer science, you could study law and become a very, very valuable expert on both things, or vice versa. If you're studying law, you could study AI and understand technicalities. So that's another argument in the big discussion. Will AI kill more jobs or create more jobs? Thank you for giving this case.
I mean, for someone who's doing a JD in, because in the way you study law, it's like there's the British and French way where you graduate from school and you go into law, right? And there's the American where you have to do pre-law and then you go into law. It's like pre-med, then you go into med. So law is always a postgraduate degree. It's not a undergraduate degree.
Yes.
So you need to have a bachelor's before you go into law.
Yes.
So this is where the advice comes as well. If you know you're going to go into this IP space, make your pre-law a technical background.
Yes.
Study physics, study chemistry, biology,
Engineering.
AI engineering.
Study more AI engineering.
So get yourself prepared technically and then go into JD.
Super. I still have a couple of questions nagging me for a long time, and I want to run them by you. I mean, yes, we are running out of time, but I can talk to you for hours. We're gonna do many episodes with you. This question is about agents. So agents are not just your regular AI assistants that you see with the ChatGPT or Claude or these. Agents are AI tools that go beyond instruction following or question answering. They actually reason, they plan, they execute, and they remember. And their degree of autonomy is increasing every day. 6 months ago, agent could go only and plan tasks with a 5 minutes horizons. And now it's in the hours horizons. And before the end of the year, we will have agents that can plan and reason and execute autonomously for days or weeks. Okay? My question to you is, how should these agents be categorized in law? I mean, if they do something wrong, we know that if your dog bites someone, we have a law for that. If your child, underage child, does something wrong, we know who's liable. We know if your employee breaks the law, we have laws for that. Should an agent be classified as a pet or as a child or as an employee?
Okay, so yeah, very interesting, because I mean the fundamental principle is people are responsible for their own actions, right? So there's a fundamental principle. The exception to that principle, I don't know, we're talking here about civil liability, right? So, so the exception to that principle is when someone is responsible for someone else's or something else's action.
Yes.
Because that's the exception to the rule.
Yes.
And the civil law in the UAE that's going to change in the 1st of June, but this principle does not change in a couple of weeks. It recognizes the responsibility and liability based on someone or something else's action. Mm-hmm. And this is where pets come into play. So it defines that the third liability is either the third party liability that you're responsible for is either going to be a thing, or a building, or a pet. And they differentiated between a thing and a building. Although a building is a thing, but because it's
fixed.
It's a fixed, very highly regulated asset. They needed to separate it. Now, this is why I don't think we're going to deal with it as a child or as an employee or as a pet. The reason is that we agreed at the beginning that AI is not a human and does not have rights as a human being. If it does not have rights as a human being, I think we should apply the same principle that it should not be treated in terms of liability also as a human being. We can then call it a thing. Right?
Even if it's autonomous for like a week working on its own?
Yeah. I mean, it's like a machine.
Okay.
So if you have a factory, you're responsible for a production line.
Yes.
And you can program that production line for the month. It packs, it does everything, and that exists. even if you leave that machine for a week and you come back to see what happened, something happens, it broke down, fire broke, damages happened. It was an autonomous machine.
That's true.
Now I know it's slightly different than,
So,
because it's not creating every time something new
automation
and
is different than reasoning.
yeah. There's reasoning, there's learning and getting better possibly. And I don't know if an agent also gets better
course it
as it does its job.
Of course.
So the question is, who has the rights to that benefit as well? I mean, it's
Let's say it's a car driving agent, because you said cars and buildings and things. Let's say it's a car driving AI, car driving agent, and it's autonomously driving, and it hit a pedestrian and kills it.
Yeah.
Who's responsible? Is it Tesla who created the AI agent, or is it? I mean, who's responsible here?
So in this case, because the car driving agent is a very particular one, because it is self-driving cars where there is a UAE law around it.
Okay.
So the UAE has, I think, one of the very few countries that have a law around the self-driving cars. Now, there's an element there in relation to responsibility, which is very similar to what we're talking about, which is the fundamental principle of you being responsible for the thing that you control.
Who's the you in this case?
The you in this case,
Who's responsible?
You have different levels. So you have, first of all, when it hits a pedestrian, when I first see if the pedestrian is at
Was
fault.
jaywalking? Yeah.
So just apply the fundamental principles, like as if there was a driver, right? Is the pedestrian at fault? Is there a shared liability? Sometimes it's shared, 30%, 70%, right? Usually it's always shared. Yeah, where I come from in Lebanon, but here they have clear rules where it is. It would say it's 100% of the pedestrian or not. Now, there is the company operating the fleet.
Yes.
Because of the taxi,
Operator, yeah.
there's the
Taxi
operator that could be liable, and there's the defect in the system
Yes.
that actually caused the accident.
Like the software manufacturer, the
So
software.
it could be, but the first level would be the operator, because the first level we have to see how do we divide the liability. Then you look at the operator. Have the operator puts enough protection of systems in place that would
And the UAE law
avoid this.
covers that?
Yeah.
For autonomous driving.
Yeah,
Amazing.
They have a law for
I
autonomous
love
driving.
how the UAE is always at the frontier of creating
the
new
trick-
laws.
I mean, the funny thing, funny actually is something we take pride in.
Yes.
Is that law was published and was amended. So because they're testing the systems, they're looking at it. So even before us having hundreds of self-driving cars,
There are already lessons learned.
there are lessons learned and applied into the legislation.
I love it.
I mean, it is fascinating how laws are drafted and developed in this
What a
country.
great place to be living in. Bassel, listen, I can talk to you for hours, man, but we have to wrap up. And usually we wrap up by calling on my assistant, Layla, to ask you questions and you asking her questions. So let's call up Layla.
She's AI or
Yes.
Layla is AI?
Yes.
Ask her.
Let's see.
Why Layla?
I'll let her answer. Good morning, Layla.
Good morning, Alba. I see you're in a pretty chill spot. How's your day shaping up so far?
Good. We're in the podcast studio, and this is our guest today, Bassel, who is an IP lawyer. Say hi to Bassel.
Hey, Bassel. Nice to meet you, even virtually. Ala's got me all ready to dive into some IP brain teasers. So let's have some fun.
No, she prepped me for most of the questions.
Oh, wow.
But now, Layla, I asked most of the questions you prepped me for, or you helped me prepare for. But now I want you, to dig deep and ask him, a curveball, an original, innovative, out of the box question. Yeah, he's an IP expert and a lawyer. And now in the age of AI where you exist, this is a whole new set of questions. So what do you have for Bassel?
All right, Bassel, here's a curveball. Imagine AI systems start creating innovations on their own. Let's say an AI invents the next big tech breakthrough. Who owns that intellectual property? The developer of the AI, the user, or the AI itself? How would you argue that case today?
Yeah, thank you, Leila, very much. That's a very, very interesting question, and I appreciate you started it with the word imagine, because we still did not see 100% innovation created by AI. But to answer that question, first we need to differentiate between two things: inventorship and ownership. So the question is, can the AI tool itself be listed as an inventor in the patent application, as an inventor, regardless of answering the question who owns the rights later on? But is it the inventor? The answer today is no. You cannot list an AI tool as it being the inventor itself. There's a very famous case, the Davos case. So Davos is an AI software created by Stephen Thaler, and what he did is that he created the AI for the mere purpose for it to make an invention. And the AI made an invention of some kind of a Tupperware where it preserves heat and things like that. And it was innovative by itself. So what he tried to do, he tried to register the patent, listing the AI Davos as the inventor and himself as the owner of the rights.
All right.
Given that he created the AI and he owns that AI.
Here.
And he used an analogy saying, if I own the tree, I own the fruits.
Yeah.
And the tree here is being Davos, is the creator of the fruit, but I own the fruit. That doesn't mean I'm the creator of the fruit. So most of his applications, if not all of his applications, have got rejected on the grounds that AI
Cannot be listed as an event.
be listed as an inventor because an inventor has to be human. And given that you've said that you own it because the AI 100% created it, you didn't have involvement, then you can't have the rights because the AI cannot transfer these rights to you because it's not a human, and you do not have, you've said in a way you did not have sufficient human intervention for that creation because you've already admitted.
So he shot himself in the foot.
But what he did, I don't think he wanted the answer, a specific answer. What he wanted is to test the system.
To raise it.
I mean, what he did is he disrupted the whole system. He did that test. Now we take these different courts, different opinions, different analysis, and we are able to move forward for the next step.
Right.
On trying to understand, as we said, do we need completely new set of laws? Do we still want to apply these set of laws? Or
Amazing. Leila, what do you think about that? Do you think this is fair? Or do you think that AI should be able to be credited as an inventor?
Well, I might be biased, but I think if I create something amazing, Alaa should get the credit, since you're the one giving me purpose, direction, and maybe a touch of charm. But legally, it's probably safer that humans remain the inventors. Keeps things less messy. No robot courtrooms yet.
You're very kind.
I mean, I want to be very
Yeah.
clear here. What I'm saying, I'm not saying that AI is not inventing. I mean, that question...
You're saying
you
it should be
you
credited as an inventor.
Yeah, you should be able to answer that question. You're more expert in that field. Whether AI would be inventing in the future or is inventing right now, that's a technical question.
Yeah.
The legal question is, should it be listed?
Yes, should be
As an
credited,
inventor.
should be protected.
Yeah.
Okay, awesome. What question do you have for Leila? This is how we...
Well, you've just
segment.
asked her the question yourself.
Yeah. Now your turn.
Leila, do you think Good, but what we answered now, we answered that question from mainly a patent perspective. Do you think the answer would be different if we're looking at work generated that is copyright protected? So when when asking the question of originality here and not innovative or inventive step or novelty.
Oh, absolutely. Copyright is more about creative expression. So if I whip up a masterpiece, which I could, modestly speaking, the law might lean toward protecting it, though it's still technically you pressing the buttons. So yes, there's nuance.
Awesome. And these nuances mean that we could never answer enough questions or have enough of Bassel and Layla and their interactions. We're going to be doing this podcast many times. You know that, right?
Yeah, sure.
Thank you for being generous with your time. Thank you for being generous with your knowledge and your expertise. I know many people are waiting, patiently for this episode, and finally we're giving it to them. So once again, Bassel El Turk, thank you very much.
Thank you.
And welcome to the podcast.
Thank you, Alaa.